Welcome, and thank you for joining the third annual UK Competition Litigation Conference. We hope you have enjoying our series. This is our final session, a conversation with the president of the CAT. Before we get started, I would like to cover a few housekeeping items. All attendees will be muted. You may submit text questions by typing them into the question and answer pane of your Zoom control panel, and we will aim to answer it during the Q&A portion of today's webinar. If you have any technology issues, please use the Q&A box as well, and I will assist you. Today's session is being recorded. You will receive a follow-up email with a link to view the recording. We welcome you to revisit the content at any time and share it with colleagues. You may also revisit any of our other sessions that have been in this conference. Once you leave today's webinar, a brief survey will appear in your browser. We appreciate any feedback you have to offer. Lastly, the opinions expressed in this webinar are solely of the speakers and do not reflect the opinions and beliefs of their organizations or affiliates unless expressed explicitly. And with that, it's my pleasure to turn it over to James Millsop.
Oh, good afternoon. My name is James Millsop. I'm a Managing Director at NERA, and I chair NERA's Global Antitrust and Competition Practice. I'm based in New Zealand and work on competition projects across New Zealand, Australia, and Asia. It is my pleasure to welcome you to this final session of the third annual conference on competition litigation in the UK. Today's session is a highlight, a conversation with the Honourable Mr. Justice Marcus Smith, one of the first public addresses since Mr. Justice Smith was appointed as President of the Competition Appeal Tribunal just over a month ago. It is also my pleasure to introduce Philip Moser, who will be leading the conversation with Mr. Justice Smith. Philip is a Queen's Counsel and is the joint head of Moncton Chambers. Philip is a leading silk in competition, procurement and commercial law, having appeared in every division of the High Court and at every level of the UK and EU courts. So without further ado, over to you, Philip.
Well, thank you very much, James. And it's my pleasure in turn to welcome Mr. Justice Marcus Smith, the new President of the Competition Appeal Tribunal. Good afternoon, Marcus.
Good afternoon to you, Philip.
Belated congratulations on your appointment.
Well, thank you very much, and thank you for asking me to participate in today's session. It's much appreciated.
We're really delighted to have you. And I thought it might be fitting to start with a general chat about what you see as your biggest challenge in taking over the presidency of the CAT.
Well, I suppose I should start by saying that I didn't regard myself as a stranger to the CAT at all in coming in as president. I mean, I've been a chair at the CAT for longer than I suspect anybody else cares to remember. I was appointed in late 2009 and have sat not hugely regularly when I was in the Chancery Division, but before that, pretty regularly as chair. So I felt I had a pretty good idea of how the CAT was run, and frankly, I've always had huge admiration for its organisation and the way it does its business. So although I wouldn't want to say I was expecting an easy ride and an easy job, I wasn't expecting hugely new challenges, because I knew I was coming into an organisation that is well run and well respected. That said, I think what has struck me in the month I've been in, when I've seen the work that the CAT does from a different angle, is just how busy the CAT is. In the early days, I think everyone recognised when Christopher Bellamy was building the jurisdiction, there was a lot of famine and not very much feast. During my time, I think the work was increasing, but well under control. What there has happened in the last few years is a real ballooning of work, in that the jurisdictions that the CAT has been allocated have increased. So it started off as just the appeals from regulators. We then got certain private actions. Those have increased, and collective actions have added to the pool. So the challenge, I think, is one of scaling up. We've got 2 very good courtrooms, but I can see points next year where we'll be thinking, actually, we're going to need 3. We may be able to deal with the overspill in terms of court allocation by doing some hearings, the procedural ones, wholly remote, but that will require additional functionality and additional space. And as with all things, you can't just look at the space requirements. It's things like number of available judges, ordinary members we are a little bit short of, and the staff who do a superb job in the background. They too need to be scaled up. So that, I think, was the thing that struck me most when I did a sort of audit of where the CAT was. And I think that is probably the chief challenge that I will face. It's a question of persuading our sponsoring department, and to be clear, they're very supportive, but we all know that budgets are tight and times are hard, that the CAT is worthy of, deserves and needs that kind of expansion in order to carry on doing the really very important job that it does. So that, I think, is the big challenge. There's a subsidiary one, which is a sort of hobby horse of mine, which is I am very keen that we move to a complete end-to-end paperless environment. Now, a lot of what we do is already paperless, but it's not very joined up. And what I would like to see within the next couple of years is a situation where parties can file online, everything is handled online, it goes into files for tribunal members to look at, annotate and work on paperlessly, and it leads to a court environment where counsel are summoning up documents, much as they do through magnum opus in some cases, into court, and it's all one system, streamlined, notes are kept with those documents, and we have a proper 21st century paperless environment. So that is an ambition I've got, which is in itself a challenge. I mean, IT issues are always a challenge, but something that I'm quite keen that we progress.
I mean, that's very interesting. It plays into 2 things, I think. The one thing it plays into is the way that the CAT does business, which, unlike, I suppose, when you were sitting as a judge in the Chancery Division, the CAT is very hands-on, or rather, you have to be very hands-on, reactive to letters coming in and applications, and end-to-end management of cases, not having some other maybe more junior judge handling procedural matters. So the CAT does it all. And I suppose also the remote working that's been forced on us, but I don't know how you see it, but I think that it's easier to do the paperless stuff when it's online, because you've got it all there on screen. And I know there are screens in court as well. It's actually an advantage, I think. Do you?
Well, I certainly agree that when you do remote hearings, you've almost inevitably got to provide the documentation electronically as well. And that has a number of efficiencies. However, I do think that there is a lot we can do better in terms of the packaging of documents so that judges can do their job better. So even before COVID struck, I'd done 3 or 4 pretty large trials entirely electronically. We're talking 5-6 weekers where I made a policy decision. I wasn't going to have trial bundles in paper form. I was going to use whatever system the parties had agreed. And that does work extremely well. It means you can choose the environment in which you work. You can search through files very easily. There are considerable advantages, but I have to say it did add about 20% to my judgment writing time, doing things electronically rather than paper bundles. And I've asked myself why. And my practice when I've got paper bundles is you've got the bundles there in court. Counsel refers you to something. You train yourself, just slap a post-it note on the page and write down the day the witness being cross-examined and the person doing the cross-examining. And you just do that whilst the witness is finding the page, because the one thing you learn as a judge is to get to bundle references quicker than anybody else because you do it so often. So while the witness is looking for the bundle, you've written that down, you've got a post-it note, and then you mark up on the page the points that are made in relation to the document. And that too is incredibly physical, easy and tactile with highlighters and pencils and whatever you use. So by the end of a hearing, I'll have 20 lever arch files with a little row of post-it notes in their top left-hand corner, indicating the documents that I really ought to be looking at again. And as I write my judgment, I shunt those over to the other side of the page. And by the time the judgment is finished, I know I've covered the documents that people have referred me to. I'll have covered other documents, but I know it's a job done. I won't have missed anything. Now, that process is remarkably hard to replicate electronically, and so far as I know, hasn't been done. I know there is a functionality to trawl through the pages that have been referred to, but the sheer ease of use, and it may be just the physicality of paper files, we do still need to do some work on that. And one of the things I would like to do is to get a system of electronic working that is not just an acceptable but not quite so good alternative to paper files, but is something that you positively want to use, and you're really happy to see paperless. Whereas at the moment, I think there's a touch of regret in all of us that we don't have the bundles. We accept it has to be that way, but we think it could be better, and I do think it could be better.
I know there's a sort of almost magic process where in the bundles you know exactly where the page is physically. There are, of course, these systems with electronic sticky notes, and that may be the way forward. But coming back to something else you said, you talked about the different kinds of cases that have been dealt with, even in the month that you've been in post, but of course that you've seen before sitting. Now, I know I've been pretty focused on collective actions this year and the first certifications that we've had in such cases. What do you consider have been the key strategic developments in CAT case law this past year?
Well, I mean, you've put your finger on it. It has to be collective proceedings. It is, I think, the inevitable consequence of any significant legislative change that it's tested in the courts. And the trouble with testing in the courts means it means testing in not just the CAT, but in the Court of Appeal and the Supreme Court. And we all know the logjam that was occasioned by the entirely right appeal up to the Supreme Court of Merits. We had to hold things back whilst we worked out what sort of regime we actually have. And the problem is that Merits is just the start. There are a number of actions going on, testing and inquiring into different parts of the foothills of the collective actions regime. So I tried in July, and the judgment will be out shortly in the O'Higgins matter. So that's the first carriage dispute that arises. We've had a number of cases where different aspects of the system are being road tested. Most of them are going to the Court of Appeal. There will be more to come before we really get the proper shape and bedded down shape of this new regime. And what's exciting about it, but what is the challenge, is I don't think we expected quite so many applications for certification as we have got. But there are a great deal, and it's creating a great deal of very interesting work. But speaking as president, a slightly worrying amount of work, because we do need to have the resources to deal with them efficiently. And then going forward, we've got no real feel for the difficulties involved in assessing settlements, because of course the tribunal has a role there, and how many of these cases will or won't settle, and whether we are going to be trying, 10% of these 10, 12, 20-week actions, or 50%. It's a great challenge, these foothills of the collective proceedings regime. When they come to trial, I suspect actually they'll revert to type and be much more like the normal competition infringement damages case that we know very well. But at the moment, we're in new territory.
I mean, that's I guess the capacity issue you addressed earlier. It's an unknown capacity issue for you. You don't know what to plan for.
That's absolutely right. That is a problem. I mean, we do our best, but hopefully we'll get it right.
Now, some of these collective actions involve and in big tech cases, there's been a huge growth in applications. Now, in the past, these would have been things for the regulator in the main. To what extent do you think these cases lend themselves to being dealt with and determined in the courtroom, or are they cases where regulatory handling with lengthy investigations is the only way to go? How will they be dealt with on a litigation basis?
Well, of course, the regulatory inquiry almost inevitably translates into some kind of litigation before the cat through the appeals. So in an odd sense, what you're really asking is, what is the difference between handling a very complex, say, the farmer case, which I did a CMC in yesterday, 5 appeals, hugely complicated decision, no secret, very difficult thing to case manage, versus a first instance private dispute, also involving multiple parties, similarly very difficult issues. The difference is probably disclosure between the two, and disclosure is something which I think we do need to take a very careful look at. So let me start with that before I go on to the other dynamics that I think arise in all of these cases. I mean, disclosure, it's no secret, is seen as one of the big selling points of the English jurisdiction. It's a hugely attractive way of finding out what a case is all about, and I think it is an enormous attraction in the litigation environment here. But it costs an awful lot of money, and it is becoming really quite unwieldy in terms of electronic disclosure and the identification of documents. It's really quite scary when you see in litigation budgets that disclosure is, it's not 500,000 anymore, it's 1 million and then some. And usually these are underestimates when you look at the final bill. This is a problem. I am not sure how far the present disclosure pilot has completely solved the issue. I think it's obviously a step in the right direction. But I don't think we are yet in a position, speaking about litigation generally, to say we have solved the disclosure problem whilst keeping the benefits of the situation. Competition cases, I think, do have a significant advantage in that the economist almost always plays a very serious and important role in resolving the dispute. And at the back of my mind, I've got a thought that we should, in fact, eliminate disclosure as a stage in competition proceedings, and instead have a situation where it is up to the economists at an extraordinarily early stage to frame what it is they want in terms of data that they need to see to give teeth to their report, and that one has a regime that doesn't provide articulated lorries worth or the electronic equivalent of data, but instead says to the economists, sit down, work out what you want, work out what you haven't got, tell us, we'll find it, and make the appropriate orders to deliver it to you. You produce your reports, we can supplement that as we go along, but that is the process of targeted disclosure. We don't have long lists of schedules compiled by the lawyers. We go to the people who are actually going to be delivering the evidence at the end of the day and say, look, you don't have the luxury of thinking about this until post-disclosure. The buck starts with you, and we want to know what you need. And that, I think, will concentrate minds quite significantly. It is a big change that I am, well, we'll obviously want to consult with users and take a view, but it's something which I feel may be a way in competition cases. I don't think it works elsewhere, but I think it does work in the sort of work we're doing. So that's dealing with disclosure, but I'll pause there to ask you, give you a chance to sort of ask a follow-up before I go on to the other dynamics and complexities of these cases.
No, it's fascinating, and I mean, if I may offer a view from someone who mediates as a mediator and also represents people, what you describe is what actually happens in mediation when you mediate before there's been disclosure. Of course, you have to have some basis for a settlement, and so what you get is the experts get together, and without £500,000 or £1 million worth of disclosure, it's remarkable that they say, well, we need this, this, and that. And you effectively replicate what you've just described for the purposes of a mediation, sometimes over a matter of weeks rather than months. So that's very interesting. Also, one thought that I had is whether there was mileage in discouraging early expert evidence to speed matters up. But from your thinking, it seems it's not so much the experts, that actually the experts can accelerate. It's not so much the experts, it's more the paperwork, the electronic disclosure in particular.
Yes, I mean, I think the trouble is we as as English lawyers, UK lawyers, but my focus, I mean, my training is as an English barrister. We are very set in our ways, and that's not necessarily a bad thing, because frankly, I think the UK litigation process is actually extremely good one. I think the users of the courts in this jurisdiction are incredibly well served, and I do think that in terms of your containable dispute, your 2-week trial, we've probably got it largely right. And things like the practice direction and the more recent directional witness statements, these are good correctives, and one always wants to look to do a better job. But I don't think that you want to be saying in these ordinary cases, if I may call them that, that you need to take an axe to the process and rewrite it. In the very big cases, I do think that disclosure has got out of control, and that's a pretty common view. And so one needs to look.
I'm sorry. Yeah.
No, do go on.
I was just going to say, on the other hand, just to be devil's advocate, one reason people do choose the UK jurisdiction is because you find things out. And if you're looking for that email that says, let's fix a price, or let's go and play golf and I'll tell you what we're planning to do about our margins, that won't come out in the special disclosure that you ask for as an expert.
Well, that is absolutely right. And I think one has got to differentiate between what one is looking for. What I'm really focusing on is those areas where you've got, let's say, a really difficult market definition question, or question of size of an undertaking in the market. And that is something which is going to be central. My experience is that we try and crack that particular nut by vast disclosure, or you're trying to assess the damages consequences of a found infringement in a follow-on case. Again, we seem to approach this, our first touch of the ball, to say, oh, we need shed loads of documents. That's where I think we're wrong. Now, just to answer your pushback, I completely agree. If you are saying, I'm alleging, without any kind of regulatory decision, that this cartel existed, and that undertakings A, B, and C were being extremely naughty in a very secretive way, then absolutely you get the most specific and intrusive disclosure that this jurisdiction can offer, because you're not going to get to the truth otherwise. But actually, there aren't that many cases, in my experience, which call for that, because the issues aren't that. Most people litigate when they've got the banker of an infringement decision behind them, and they're looking to monetize it. So it's those cases where the economists are, I think, front and center, market definition, assessment of damages, that sort of thing. And what I find is that there's and I'm sure this isn't the economists, I'm quite sure this is the litigation strategy, which is to keep things as fluid as possible until you get to trial. So you want maximum disclosure because you don't want to miss anything. And you don't want the economists to be nailed down in terms of the public material that doesn't have to be disclosed that they rely upon. So in one of my cases, I said, in a somewhat bespoke order, first of all, the economists had to say what disclosure they wanted. Secondly, they had to identify the list of publicly available material they proposed to rely upon. Now, they hated that. And what they came back with was the only bit of the order that I think they both agreed was a list of the most generic 10 things that they would look at in order to produce their report. So it was basically all of the internet and everything else. So I went back and said, I'm sorry, I want a specific list. Don't mind you adding to it over time, though it'll be harder to add as time goes by. But if you don't give me a specific list, you're not using it. And it's this crystallization of the position early in this sort of case that I think really will make a difference in making people think, what exactly is it that my theory of harm is? And I think the theory comes before the disclosure, not afterwards, in this sort of case.
Yes. Yes. I mean, that is extremely interesting. At the other end of things, not every case is a worldwide cartel. It's not all tech giants. And so I think people are also going to be interested in what's going to happen and what the CAT will actually do about access to the tribunal for the smaller claims. Mm. And that's probably also an aspect of this, isn't it?
Well, I think you're right. The oddity is, I think that the trend is for bigger and more expensive and more value at risk cases than the converse. I entirely agree that it would be wrong in principle if we were to disregard the small case. But actually, I think one of the advantages of the very hands-on, judge-led litigation that the CAT really has as its hallmark is that we can look after the little cases very well. I mean, my introduction to the business of judging at the CAT in 2010 was the cover pricing dispute of the OFT, when we got 26 appeals landing on our doorstep on, I think, the same day out of a single OFT decision. So that was an immediate case management nightmare for Gerald Barling, who was then the president. And I had the great pleasure of sitting with him on my sort of first 3 cases, doing some of these appeals. And the interesting thing about the cover pricing appeals is that quite a large number of the appellants were actually very small building entities. I mean, some were very large, some were like Kia, but some were very small. And we did have a problem in ensuring that they were appropriately protected. But actually, I think small parties are helped by having both an expert and a hands-on tribunal, because when you're against a large and well-organized organization, in this case, these small organizations were against the OFT, which had been conducting this huge inquiry and had a huge resource in terms of acquired knowledge. Well, I think we were well able to make sure that the little fish looked after themselves. We don't have a regime particularly like the IPEC regime of costs capping or anything like that. I'd be prepared to contemplate it if it was seen to be a good thing, and IPEC has been a great success, it's fair to say. But I feel that our processes are sufficiently flexible and sufficiently hands-on that we can handle the small fish, if I can call them that, and the small claims very well. I don't see it as a big problem because I think we've got sufficient processes which have worked historically to be able to give these cases the appropriate direction. I think that the problem cases are the really big ones, and that's because the dynamic of solving really contentious big questions, or actually thousands of contentious small questions that aggregate into a big claim, resolving those in a single trial is, I think, the problem. And you started out by saying these tech cases, can we do them in court? Well, to cut to the chase, we've talked about disclosure, and I think in terms of big tech cases, whether they arise on appeal or whether they arise as first instance disputes amongst private parties, have very similar characteristics, and those characteristics are a basic intractability. You have got multiple parties, you've got enormously complicated disputes where actually you don't get from the pleadings a clear enough articulation. And this is not a criticism, it is a fundamental problem about how these issues in these cases need to be unpacked. You have an essential lack of oversight as to what really is in dispute and what isn't. And the problem I think that we have is that all of these actions, because this is the way we do things, are heading for a single big trial. And then you're talking about, 8, 10, 12 weeks of litigation in court. And the problem for the parties and the problem for the tribunal is resolving these enormously complicated factual, legal, and technical issues in a single trial is actually a very tall order. And I don't think that is particularly sustainable going forward. Now, the problem is, it's like Churchill's answer to democracy. It's a terrible system, but it's better than all the other even more terrible systems. And I think that may be a truth about how we do business in this jurisdiction. We've actually got a pretty good system, and the one thing no judge wants to do is break it. But that being said, I think we do have to give quite serious thought as to a kind of phasing approach, where maybe what the parties need to be doing in their pleadings is actually setting out not merely the points of dispute, admit, not admit, deny, but actually ordering the issues in a manner so that the issues that are fundamental are decided earlier, so that the contingencies are removed. What one can't really have, I don't think, is a situation where you've got a fundamental point in play. Say, take a nice easy thing. Well, I say nice and easy. I'm sure it's not. Dominance and abuse of dominance. Now, you can't really talk about abuse until you've nailed dominance. Yet, in many cases, you are going to have everything up for grabs, and all of the submissions and all of the evidence are directed on the basis that if dominance is live, you've got to argue about abuse on a kind of contingent basis. It's probably better, if you can manage it, to knock on the head the market definition and the dominance question, let the parties take stock, and then work out what the argument on abuse is. Now, that of course sounds awfully easy in the abstract. The problem is organizing it in a way that is as efficient as the single rush to trial is an extremely tall order. And the trouble is, what I'm sounding like is remarkably like a civilian judge in Germany and France, where this is how they do it. The trouble is, they do it with large gaps between each stage of the hearing, and more often than not, appeals after each stage of the hearing, with the result that you've got a process that doesn't get resolved end to end in 12 months. You've got a process where each stage gets resolved end to end in 12 months. You then have the appeal for a further 12 months, and before you know it, your litigation is stretching into the decades rather than the months.
Yes,
so
yes.
The question is, can we have our cake and eat it? I would like to think that we can, but that's because I'm an optimist, and I think that we've got an incredibly pragmatic and capable legal profession. I think London and the UK are a hugely rich legal resource, and I'm not talking about the judges. I mean, we're wonderful, obviously, but I'm not talking about the judges. I'm talking about the legal professionals who work in this jurisdiction. And the fact is, the courts in this country would not have the reputation they do without the outstanding service that is provided to them, not just by the bar, not just by the solicitor's profession, but by the whole supporting apparatus in the shape of economic consultancies, accountancies, all of the range of experts who make the system work. And I think that if we put our minds to it, we can get a UK plus process where we can stage things and do it fast. But don't ask me how we're going to do it, because that's something I'm really thinking about.
It's a whole ecosystem, isn't it? Including the funders and all of those clustered around the cat and making it work. I like your image of having the cake and eating it, combined with your idea of slicing it up. I'm sure there's some clever image to be discussed about the cake being sliced up in just the right way, so that it can be managed and digested. It might be worth just at the tail end of this, just to mention that there is the fast track process also. If we're
Of
talking
course.
about smaller matters, I think I did the first ever fast track case, which was something about badgers and vaccinations, which eventually settled. But that does also exist.
It does exist, and it is used, but really in support of the point I made earlier, it's not often used. And I think that's because we don't often have the sort of case that can benefit from its use. But yes, we do have it. And to be clear, if we had the sort of problem that the patents court had, which resulted in the IPEC being created out of the IP county court, we would really devote time and resource to it. It's because we don't really perceive that there's a problem in terms of our dealing with small cases being in any way out of line with small cases elsewhere. I mean, I think you'll get a much more efficient service here than you will in any high court or district registry or county court action, because we are hands-on and we have enough judges to do the business efficiently. I mean, the state that the cat is in is that, and the state we want to be in is that we want to be able to offer a trial date which will cause the parties a sufficient amount of happy concern. Can I get this done in time? We don't want them overpressured, but we don't want them thinking, oh, do you know, I can take my foot off the accelerator for 6 months because nothing's going to happen. We want people to have their feet to the fire sufficiently close that they get uncomfortably warm without getting burnt. And that is the sort of resourcing that I want to maintain, so that we carry on being regarded as a very efficient tribunal to do business. In other words, I want the parties to say to us, can you go a little slower, please, rather than hurry up.
And you've got it all there on a publicly available website, including the diary and the past hearings. So that's I think, extremely user-friendly. Just thinking about things that take time and moving to a different topic, confidentiality. Confidentiality, obviously, often an issue in CAT cases. Confidentiality rings, very well-known device. We have found it can sometimes still take a surprisingly long time and money to agree these between the parties. Do you think it might be time for a CAT practice direction or a protocol, maybe with an approved template?
Well, I mean, that's a very good question. I mean, first off, confidentiality rings. You've dropped off screen, Philip. Are you still?
I'm sorry, I'm still here as far as I know. Can you hear me?
Oh, good. Oh, you're back. Excellent. Suddenly there was you were replaced by a black screen. Confidentiality rings. Yes. Well, I mean, this is a good example of something which was sort of heavily litigated at the outset, and then just became accepted as a kind of standard form, which actually has become a model in both the patents court and elsewhere in the High Court as the way to do things. I think there is a growing trend, and I'm not sure it's a good trend, that we seem to be thinking that things that previously were unquestionably taking place in public are now to be regarded as under wraps. And that, I think, is the cause of the expense that you are quite rightly referring to. So to take a recent example, you'd probably be familiar with my extempore ruling in the BGL case, where we had a problem with confidentiality, which fed through into a problem in how we conducted the hearing. And it's worth, I think, unpacking how the problem had arisen, in that so this was a regulatory appeal, and the CMA had entirely properly, if I may say so, sought to respect the concerns that third parties that it was interviewing had expressed about confidentiality. And what the CMA had said was, look, don't worry about this. We'll keep your names under wraps. And that was the process that had informed the entire investigation process. And then it fed through into the decision. And then, and this is where I think the mistake occurred, it fed through into the litigation process. And what happened was that almost by default, the investigation confidentiality was translated into the litigation, the appeal process. And so what we ended up with was an extremely fat, in the sense of too wide, confidentiality protection come trial. And the reason this became an issue was because although counsel were very adept at referring to confidential party names by the code that we had agreed, witnesses were not. And it was becoming increasingly clear that most of the stuff that was labeled confidential wasn't, but some was. And although we all had a pretty good idea of what was confidential and what wasn't, none of us were particularly happy about judging that on the hoof. So we had to keep things confidential. So for most of the time this worked because counsel were very adept at not misspeaking. We then got to the first witness, and it was just seen as fundamentally unfair to require this witness, in addition to all of the other stresses, to expect to navigate the confidentiality ring. And so instead of saying, well, you have this sword hanging over you of misspeaking and being, in the naughty corner if you do misspeak, we went into private session. And I ordered that with a considerable amount of regret, which I think you can probably see from my judgment. Also, I think a considerable amount of crossness, and not least with myself, for not getting a grip of this earlier. And for the future, what's going to happen is that there is going to be an absolute revisiting of the confidentiality regime as it transits from the CMA investigation process into the litigation process that follows, in the sense that third parties are going to have to recognize that unless their commercial or other interests are materially at risk, their names are coming out. It's going to be published. These are open processes. And the fact that you're third party, well, you get a certain amount of additional traction. But you can't just keep your name out because you didn't want your name kept out. You can have your name kept out or other material protected if it will be harmful in a material sense if it's published. And I think we've lost sight of that. I think we've lost sight of the fact that the real strength of our processes is that they take place in public. We wash our dirty linen, if it is dirty linen, in public. People can walk into court or watch the live stream, and they see what's going on. And we lose that at our peril, because the moment you start pulling the blinds down, closing the shutters, people think something's going on when it isn't. I mean, I always am hugely disappointed when the redactions in a commission decision are removed. You think, God, was that what you're protecting? Really? How on earth can you justify that? And you think, you're expecting something much more sinister, actually. And even now, after, decades of litigation, I still have this acute sense of disappointment when the blanking is removed, because it's all so mundane. And this is what we must, I think, do. We have to eliminate the cost by killing the problem. And the killing of the problem is by a fairly ferocious reaction to those who advance confidentiality arguments in a blunderbuss blanket way, without thinking about why exactly is this important. Because to go to the other end, we are hugely aware that competition litigation in particular involves very, very sensitive material. And we absolutely want that to be protected. I mean, the cat, as we discussed, pioneered confidentiality rings. And what we need, I think, is simply to get back to a sense of what it is we are here for. We're here for doing public justice. That means not just hearings in public, but the materials being discussed in public, except where that can specifically be justified in the narrow case. And I think if we repeat that message a few more times, the costs problem will go.
It will take care of itself. I think, in view of the time, there's an area that I'm very keen to come on to, and then we'll see if there's space at the end. But what I'd like to come on to is judicial review in the CAT. And judicial review, famously flexible. What possible differences do you see between judicial review of an impartial independent regulator, so the CAT's current JR remit, for instance, in merger control, and then under the CAT's new subsidy control jurisdiction, how is that going to work? What I'm thinking about is JR of the reasoning of public authorities in what was state aid is now subsidy control principles, or assessing the market economy investor test. And that reasoning, in reality, is often going to be driven by policy objectives, even sometimes political objectives. How do you foresee that going?
Well, let's start with a somewhat annoying health warning, in the sense that the problem with the subsidy control regime is that we're not really sure in sufficient specifics how exactly it's going to work. I mean, the bill is still going through Parliament, but the really important stuff will be in the rules that will follow the bill, that will articulate more closely the jurisdiction that we have. And then there will be the important first few cases, which who knows when they will come, and who knows how many there will be. But we will have a similar process to what we are experiencing at the moment with the collective proceedings. There will be a feeling of one's way. So that's a sort of warning that you're not going to get much of a specific answer to that question. But let me instead give you a slightly heretical answer, which is I am not sure of how much difference there really is between JR and merits reviews in this sort of regulatory case. One of the first cases that I decided when I was a wet behind the ears chair, feeling my way, was the extent to which a merits appeal was limited by the grounds of appeal, because we had an argument. It was Ofcom and BT, one of the many Ofcom BT cases I did, so I can't give you a more specific citation than that. But the question was just what could you do on the merits appeal? What did it mean? And two things emerged from my judgment, affirmed on appeal, and now sort of set out in Nick Green's latest judgment in Flynn. Two things emerged. First of all, a on the merits appeal is not an on the merits revisiting of the whole matter in dispute. What it is a targeted review of the grounds of appeal. And if it's not in the grounds of appeal, it's not reviewed. So there's an immediate narrowing there. One isn't revisiting the whole thing. It's not a rehearing. It's targeted. And unless you target things sufficiently clearly, it's either going to get struck out or not be heard in some other way. So that's the first control. The second point which emerged from these cases was that, much like judicial review, we will attach considerable weight to the policy decisions of the regulator in question. If Ofcom have got a range of options, all of which are reasonable for regulating a particular question, well, I don't see it as our job to say, well, we disagree. We think that reasonable option C is to be preferred over reasonable option A, which you picked. That, it seems to me, is a usurpation of the role of regulators who do a hugely important frontline job. Now, when you get to that stage, you start thinking, well, hang on a minute, just how far does an on the merits review differ from JR? And I think, and I'm on record for this, I mean, I've written about this, I don't think the difference is as great. I think both are flexible. So the first question will be how far policy questions arise when a subsidy is being challenged before us. And I suspect that there'll be quite a lot of that. I mean, I have no idea, but I suspect there will be. But I think that you can take it that unless the rules really oblige a different approach, we ought to be according a significant amount of respect to the person whose job it is to allocate or not allocate the subsidy in question. So I think this is going to be hugely interesting and difficult work, but I am not particularly hung up about the JR label. And I think one of the things that perhaps needs to be exploded in the minds of those who think that JR is a way of insulating decisions from review. A lot of people like JR because they think wrongly that certain things can be ring fenced from the judge's looks review. The fact is that JR is itself hugely flexible. I don't like the label proportionality, but the more important an issue, the more intrusive we're going to become. And it's common sense. If you've got a question which is, how many paper clips should a low-level functionary in a low-level department have ordered? Is it 200 or 300? Well, you're not going to get much review on that. I think we'll give the stationary order a bit of discretion to determine matters. But if you're talking about something which goes to, the fundamentals of how people live their lives, well, you're going to get a pretty sharp poking, whether it's JR or on the merits. So take, for instance, the review of the fees charged in employment tribunals. You're talking about something very basic and important there. You're talking about access to justice. You're talking about fees which they may not have been calculated, but they had the effect of cutting by about 90% the cases coming before the employment tribunal. Now, that sort of decision, with the access to justice implications it has got to be justified to several decimal places, not to numbers in the 5s and 10s, and that's judicial review, not on the merits appeal. So as I say, that's my heresy. I don't really think there's much difference.
Well, there we are, the proportionality of the intensity of review. You heard it here first, or rather you didn't if people have read what you've written. But thank you. We're sensitive to the audience's time, and we said it would be around 6:30 GMT. I'm extremely grateful for you doing this and for sharing so freely with us your thoughts. We had a few questions. I'm sorry if we can't use them all. I want to mention Simon Holmes sent a question. It's actually more of a suggestion. So Simon Holmes has written, and he said it's very interesting about dividing cases into various elements like dominance and abuse. What about taking abuse first? And because if there's no abuse, then the case is over anyway. I don't know whether you want briefly to comment on that, but that was one that tickled me.
Well, that's very interesting. I sense sort of the thinking of Peter Freeman coming in here, which is that if you can do something which is sufficiently effective in the market, which isn't competed away by people leaving you, then you are ipso facto dominant. So you don't need to look at the question of dominance. I think I disagree, but that's simply because the way in which abuse has been characterized as a competition infringement is because it is seen as a responsibility of the dominant organization not to abuse. In other words, that which I, the non-dominant entity, can do, you, as the dominant entity, can't. And then one's got concepts of super dominance where there's an even more heightened sensitivity to your responsibilities. And it does seem to me that that is, particularly in these days of digital platforms where you've got single entities wielding enormous market power, a very important test that I think we can't lose sight of. So if, and this is the question, if abuse is coloured by position in the market, and I think it is, then you've absolutely got to do the market definition and the assessment of dominance, super dominance, or no dominance first, before you can even sensibly work out whether abuse is an abuse. Because what I can do as a little trader down the road, in terms of my contractual terms, in terms of exclusionary behavior, well, if I want to do that, I should be free to. Freedom of contract is also a value. But if I am, Google, then there are some things which I ought not to do because you are Google and you're very, very big, you're very, very important, and you're very, very powerful.
The special responsibility of the dominant undertaking.
Well, I think that is the point about dominance. It is saying that you, because of your market power, are subject to obligations and responsibilities which others who are not in that very privileged position don't have to worry about.
Thank you. Well, I've used my privilege to go slightly over time, but Marcus, thank you so much. It was so interesting. It was worth it, and the recording will be available from next week. So I'll say thank you very much for this evening, and I will hand back to James, who is going to tie up the loose ends, I think. James.
Well, Philip, thank you very much. It's been a real pleasure. Thank you.
Thank you.
Yes, well, thank you to both of you for a fascinating discussion, and certainly we could talk for quite a bit longer, I think, about that idea of breaking up and sequencing the decision making. I have a few thoughts on that too. We have run out of time, but that I thought was a fascinating part of the discussion, as was the ideas about reducing disclosure costs. So thank you very much to Mr. Justice Marcus Smith and to Philip Moser QC for a fantastic discussion. With that, we're actually at the end of the third annual conference on competition litigation in the UK. Certainly, it's, I think, fair to say that competition litigation in the UK is thriving. We talked about the rise in collective actions, in particular in the abuse cases, very, very interesting. So we've been delighted that there's been over 300 people who have engaged with the conference over the last 3 days, and we're very grateful to all 20 of the speakers. Just like to say a special thanks to the team who helped deliver the conference. So that's John and Diver from Moncton Chambers, Simon from Augusta Ventures, and Thomas, Pam, Nanette, and Sarah from NERA. It's certainly great to have celebrated NERA's 60th anniversary with everybody, and we hope that next year we'll see you all again in person. Now, once everyone leaves the webinar, there will be a survey that appears in your browser to provide feedback if you feel that you'd like to do that. So really, finally, on behalf of Moncton Chambers, Augusta, and NERA Economic Consulting, thank you for joining us. We wish you a wonderful holiday season and a bright 2022. Thank you very much.